Facebook, LinkedIn, YouTube, and Twitter. And this is Coffee with a Lawyer. And we have a few guests. Someone is posting in the chat, so please feel free to post any questions in the chat. And also we have a guest with us, so I'd like to give you the opportunity to ask any legal question you may have, with the disclaimer knowing that this is not legal advice as we are live. Any specific details that you'd like to discuss, I encourage you to book a confidential consultation with an attorney. So everything we discuss here is just for general information. With that being said, please be mindful of your questions, not to go into too many specific details, and keep it general if possible. So Robin, I'd like to give you the opportunity to ask any question.
Yeah, I had a situation arise last week. I received an email from an organization called PIC Rights International, which basically said that I had infringed on a photo from a client that they represent. And so they weren't giving me a takedown order so much as they were just giving me an invoice, expecting me to pay it. Mm. So, I just, it's only for $440. Well, only for $440, but in this situation, if they tried to sue, I guess they would try and sue in a French court and expect that I would just pay after a judgment was rendered.
You bring up some good points. First things first, because there's a lot of scams out there. So I would verify that they're in fact the copyright owner. So if they're referring to any registration certificate number of registration with the Copyright Office, I would do your due diligence and look it up. Also, I would do some due diligence of the lawyer or the person that letter came from, look them up. You have to make sure they're the proper owner. And even with that being said, I would have to analyze how it is being used in your website, because there are strong arguments for fair use.
Right. Now, and that's what I made.
Yes. So you could make your arguments. I would say first verify that they're their owner, because there is a lot of scams going around. This in particular, this copyright infringement notification is really like a mill. These law firms may push them out without doing a lot of checking. So you could respond. The amount that they provided is an amount based on a fair license. That's what they're arguing, that it is this amount based on your use. We're entitled to a fair license fee.
Right.
So, I mean, you can dispute it.
I basically responded and said, hey, it's fair use. It's on a blog that is a commentary, and it is not a commercialized application. I mean, it's a very indirect commercialized application. I'm trying to give social proof and bona fides. And I also said, I captured this image in a public domain search. And so as a public domain image, I didn't attribute it because there was no attribution for me to attribute.
I understand.
So I basically said, you can send me an invoice all you want. Then later on, they sent an additional email with contracts basically stipulating that they reduced the amount of money that I owe them, and basically giving me contracts to be able to sign, which, I'm not going to sign. I mean, even if they were a legitimate company and a legitimate interest, the image quality was so poor that, that's the reason why I used it, because it didn't seem like it was a professional photo.
Here's the thing. you have to balance. Okay, you have to balance how much this work, this image, matters to your product, your website.
Right.
Is it the driving force? And if it is, that's also an
Absolutely not.
argument that it's an infringement. So if it's not the driving force, and then it's more argument for fair use. However, if it's not the driving force, I would ask yourself, what's the benefit of me maintaining this? Because you already know they're coming, they're disputing this.
Right.
So can you replace it?
I've already removed it, and they basically said in their email, you know, you can remove it if you like, but you still have an invoice. We still expect the invoice to be paid.
I would dispute it based on your arguments of fair use.
You know, basically between fair use and the quality of the image, if they actually paid for this image, it basically looks like it was an image taken from a camera phone, from an old flip phone.
Mm-hmm.
You know, grainy without very much definition. So
yes, Robin. And Jabon asked a question that's right on point. How do you avoid copyright infringement? Seek license agreements from the owners, and even if you're doing fair use, because then you can also document your good faith efforts, and that goes a long way in the court. And this loops back to you, Robin. In the court, when they make a determination of the facts, this must be decided by a jury. Okay, so if in fact you infringed the work, or if it's fair use, must be determined by the arbiters of the facts. Who's to say, all because they're writing you a letter, that they're correct? Exactly. Now, where is this correspondence in the? Is it with a collections agency? Is it they're just sending you invoices and bills? I would reply with a cease and desist. Okay.
Okay.
A cease and desist with your argument.
I didn't necessarily want to escalate to that.
Well, you can also have a non-response. A no reply is a response. And
I did reply basically, and I replied with a couple of replies to their original email.
Well, look, nothing is obligated until they pull you into a court of law. You can keep going down this rabbit hole of emails. They will continue to threaten. They will continue to say they're penalizing you. You can argue the image is removed. You can continue to assert your arguments of fair use, but you guys are just hitting heads. Really, the proper venue is a court of law. You can respond with that. The proper venue is a court of law. This has been extraneous communications that are going nowhere. I've asserted my rights. Please cease and desist.
Right. No, I guess that's probably the next step.
Mm-hmm.
And it's so far down in my email list that I can't even see where the original email is. So I just, it got me twisted up into, how do I deal with this? How do I deal with this? And it interrupted my sleep for several days until I just decided I'm going to basically tell them that, you know, this is A, it's a blog, therefore it's commentary. B, it is not a commercial use. So you can Pick Rights International on behalf of Agence France Presse. It's a Canadian, Pick Rights International is a Canadian company.
So, Robin, I would do your due diligence, look into it. There's a lot of mills out there that are sending these types of cease and desist, copyright infringement type notices to websites because they're using their images. A lot of
Right.
them are legitimate. They are the copyright holders and they're asserting rights. Uh, some of them may not be so legitimate. You have to do your due diligence.
No, I mean, this looks like it's legitimate, but it just, it is a non-starter. The image is a little bit better quality than I remembered it to be, which they've included an image, they've included a proof of use under, and then gave the blog to my website.
Well, those are some arguments that can be made for fair use. The elements are distorted, the placement within the whole it's been transformative. I think the fact that it's somewhat distorted helps your case. It's not the same image, it's been transformed. I don't know how exactly you've incorporated, but the more elements you can change, the better when you argue fair use.
Right.
The Copyright Act was not intended to restrict people from using other people's work. In fact, it was meant to inspire new creations, innovation, to allow others to take people's work and create something new. But that's the weighing factor. Is this in fact a new piece of work, or is it considered a derivative or an improper use without permission? That's the scales that you have to weigh. The Copyright Act was in fact meant to inspire creation in the arts and the sciences.
Right.
And that is good policy you can argue in your response email if you wanted to memorialize your position further. I don't think it's necessary, Robin. Even a participant in the chat said you can block them, and that's a good way to end it. Perhaps in this case, it may be. You've asserted your rights in fair use. Point made. Where do you take this? The next place where this matter belongs is within a proper venue. They have to pull you into court. And you brought up some jurisdictional issues with this entity being Canada. Are they even entitled to come into the States and assert U.S. law? You can
and the bank transfer payment is to a US or UBS Switzerland AG. So it's not even a French, it's not even a French court. I mean, a French, they're expecting me to make a payment to an international organization, which I have no idea, whether this is in actuality a truth. They have a link, basically, if you would like to settle a copyright infringement matter, please contact PIC Rights.
And they provide a link where you can just click on it and it takes you to a payment processing website. It's somewhat of a mill. That's how they run this.
Right. So it does. I mean, it looks like it's legitimate.
I've seen these firms do these type of operations. They exist. I believe they're ethical, but it is really of a volume type business, and it's a mill. And many times they don't assert, they don't follow through. Maybe they'll provide it to a collections agency, but that's essentially what this law firm is. They're a license fee collection.
They are going to escalate it to Higbee and Associates to engage in the argument with you as far as fair use. Should you wish to go that route, that would increase the cost of settlement significantly, which, as far as I'm concerned, I'm judgment proof in the first place.
Yes.
I'm going to basically stipulate.
Right. There are some people that are just judgment proof. They don't have assets to their name.
And I have assets, if they want to go after me and then, claim that I have so infringed their rights that they want several $1,000s worth of claim plus damages. They can if they like, but the only asset I really have is the car, which is valued at $1,500, and resale would probably be even lower than that. So I'm just
What could happen is that they could report it to the credit reporting agencies, and it could affect your credit.
okay.
And they could garnish any wages. They could put a lien on your property. They can garnish assets or seize assets. It's a process to collect on a judgment. All because you have a judgment. The judgment is just that, a piece of paper. Now, there are some people that are judgment proof, but that would be the post judgment methods of collecting.
Right. I mean,
it's not an easy process. And for that amount, yes, they would have to consider the cost and the benefit. A lot of times they may assign a judgment to a collections company.
right. Well, as I've had with a recent judgment that I was given, basically the lawyer said, well, they're refusing to pay it, so I will have to engage further services in order to be able to get your payment.
Mm-hmm. Yes.
And that was for $8,000.
Mm-hmm. Yes.
I mean, how much damages can they give on $400 invoice? I mean, $3,000-$4,000. I'm not sure how they. The only thing that they could really do is ding my credit, which has taken a plunge recently anyway. And in the end, my website is for my corporation, which is an LLC. So they would have to pierce the corporate shield in order to be able to get to my assets anyway.
That's a good analysis.
I mean, I just, if I hadn't found it on a public domain search, I wouldn't have used it if it had been attributed, properly on the search where it ended and where I took it off of. It would be a different story, but that wasn't the case, at least as far as my memory holds.
I've seen these situations before. I wouldn't feel threatened by it. Like I said, these are run-of-the-mill firms, but you do have to be. I'm happy you took it down. If you continued, then they could argue further damages and potentially punitive.
It wasn't, essential to the blog.
Yeah, it wasn't necessary. You didn't want to. You don't want to essentially buy yourself a lawsuit.
Yeah, no, I mean, I took as much action as I could, basically telling them.
Mm-hmm.
I just told them, you can file if you want, but I'm judgment proof.
Well, here's another good question by someone in the chat. They asked, in real life, if someone is threatening to take you to court, should we wait for them to take us to court, or should we take them to court? It's a fact-dependent situation. Okay.
Right.
There are times when you've ran out your ability to resolve matters, and a dispute is inevitable, and disputes are resolved in the courts of law. That is the proper venue in our society that we resolve our disputes. Can you take them to court? That also depends on the facts. I will say this, and I come from a plaintiff's attorney mindset, and I believe that's the best mindset, because I fight for the good against the essentially the big, the powerful, and the evil. So it is a good versus evil situation. It is an adversarial setting. You do not go into a battle with just a shield. You must have a sword. If you're going in just on a defense with a shield, you are going to lose. There's really no other option. It's either you dismiss the case, which is a loss because you had to undergo this situation, incur costs, stress, energy, time, money. It's a loss. Every dispute, there is no winners in legal disputes. Okay,
Right.
that's why you have to go in with a shield so that you can potentially come out as the winner. When you have a shield, you can assert claims. You become on the offensive. You're not just on the defensive. There is light at the end of the tunnel. There is a potential recovery. And when I speak in terms of recovery as a plaintiff's attorney, I consider it to be monetary compensation or damages, some form of monetary damages, something you can calculate, quantify. You got to put the intangible to an objective number. That's what the law attempts to do, because we cannot put people in the place they were before this incident. The law attempts to do that through its remedies. In the civil negligence realm, it's monetary damages. In the business transactional realm, it's usually your expectation interests or to rescind the deal and put them in the place had they not entered it. But it's very abstract because we cannot reverse time. We try to do it in abstract recoveries.
I basically told them I wouldn't be stupid enough to use it if there was an attribution saying that it was owned by a company. Most of the images I use are, I'm forgetting the name of the sites, but they're basically Creative Commons sites that basically have single use, non-commercial use. And I'm sure that there are on medium.com, and I'm sure that there are people that basically use images from Creative Commons for what are basically, commercial interest blogs promoting a certain product. So that would kind of crunch that.
The key is transformation. The more you can transform it into a new work, something you can call your own. That's what the Copyright Act was created for.
Right. I mean, they asked me at one point, they said, you didn't even change the image. And I'm like, well, the image quality is so poor to begin with. I didn't.
Well, I would not have said that, Robin. I would say that this is a transformative element.
Right.
I wouldn't argue that the image quality was poor. I would have said that, the image has been changed and it has transformed the work when it is considered with the whole. All right. You got to consider it in the whole of the blog. If you really want to protect yourself, you can go ahead and print out your blog and register it with the Copyright Office.
That would be too much. I mean, copyright.
Yeah, it's a matter of cost benefit. How much do you want to put into this? I think you're in a good position now to just let it go, honestly.
Right.
All right. Do you have another legal question?
No, that's it. I mean, that's what came up in the last 2 weeks. I just, I gave it way too much thought and obsessed over it too much.
Well, I would not let it do that to you, Robin, but I think you did a good job with memorializing your position, and that's key.
Right.
Okay. And yes, I understand. This is my profession. I do it all the time. You can go down the rabbit hole. You need to know when is the time to essentially release. Okay.
Well,
you made
the
your
response
point.
that I gave them today is going to be my last response.
You can even say that.
Well, I basically said, file suit as you like, but, know that I'm judgment proof. I mean, I'm not sure what else I can say. I mean, they can lean all sorts of things that they want, but I don't The car is the only property that I own. I don't own a house. I live on Social Security, so they can lien that if they like.
Absolutely.
Only $800 a month for that.
Exactly. And another question in the chat that is on point asks, should we take disputes serious and try to resolve it before it becomes huge? First and foremost, I take every legal threat serious. So once they start discussing any type of potential litigation, I take it very serious. And you may even want to respond that way to let them know that you take it serious and that you consider any frivolous attempt to be considered extortion. Now, these type of situations have to be handled lightly. Okay, once the threat of litigation is made, a lot of things change. There is potential pending litigation. We have another guest signing on. I'd like to allow to admit her into the Zoom webinar. But with that being said, every threat of litigation should be taken serious, at least
Yes.
in a response to request them to memorialize their position so you can consider it. Because you can respond and say, you know, I take these matters serious. Please provide me your legal arguments and position so that we can come to an amicable resolution. You should always proceed in good faith, clean hands.
I don't even want to escalate it that far. I've already escalated it. 3 email responses. I've already escalated.
Well,
as much
aside
as
from your personal matter, Robin, I'm talking in general, so that
Right.
so that we can give helpful suggestions to everyone here. All right. I want to give Susan a time to ask a question if she's available. Hi, Susan. Are you with us?
There she is.
Hi.
Hi, Susan.
How are you doing?
I'm doing great. How have you been? I recall we've worked together in the past.
Yes.
Yes, it's so good to connect with you again. How have you been?
Okay.
Nice.
Thank you for your help the other time.
Always. I'm happy. Yeah, I'm happy you've connected with me. So we do this every Monday, 9 a.m.
Uh-huh.
And you know, if you want to ask a question, please ask general, because there is no confidentiality here, no attorney privilege, and we are live on other streams. So, so let's be mindful of that. But if there's
I'm glad you told me that, because
Yeah.
I don't know if I want to say what I was going to say.
Yes. So let's be mindful of that.
This is like live stream to
just a weekly coffee with a lawyer is my way I can connect with the public, be of service. But again, this is not confidential, no attorney-client privilege. If you want to talk about a specific matter, it's best that we arrange a confidential consultation. But I'm happy to provide any general information.
Do you know anything about employment type? Labor laws or?
I know a bit. Okay. It is not my main area of practice. I do plaintiffs' civil litigation, as you know, but that touches on employment law, and I have many associates that are the best in employment law. The thing about employment law is that from a practical aspect, it's very document heavy. Okay, so it takes someone very experienced in employment to be able to review all those documents. And when we speak about employment law, internal emails are always the smoking gun piece of evidence. So when you work, watch what you email.
I guess my question is just, I was curious about, so I think I can ask it, but I know someone who they got injured,
Mm-hmm.
not on the job, but then like because they got injured, they tried to cancel a job booking and the employer wouldn't take no for an answer. So she got further injured. And then after that, she took her more longer to recover because she worked on the injury. And, you know, so then after that, the employer kept asking her to work, but she didn't want to work for him anymore because he didn't care that she was injured and kept, you know, wanted to pressure her to work. So
I understand
I
this.
think she wanted to file unemployment, but the guy keeps asking her to work and she just doesn't acknowledge that because she doesn't ever want to talk to that boss again. So is she eligible to file for unemployment?
Okay,
But the
well,
boss,
let's take it one step at a time. First things first, I will say the foundation of this whole situation has to be the documents, the records, the medical reports. This needs to be memorialized by a doctor. Okay, without doctor reports, I don't believe there is reason. Okay.
no,
So-
I mean, she did go to the doctor and all that stuff.
So-
It's just that she's ignoring every time her boss keeps asking her to return to work.
Well,
And
it
she does have unemployment, but I think unemployment would say, well, he did offer you work, but she doesn't want to work for him because he did, you know, he created an uncomfortable feeling for her because he wouldn't take no for an answer when she tried to cancel because she fell down on her hand. Like, how are
Okay.
you supposed to like work on that type or the job she has?
Susan, there's
is
a
very-
lot of specific facts here. I encourage you to book a confidential consultation. I will say this. I believe there's two issues here. All right. The medical records must show that she was not able to work. The doctor must say that she's not capable of returning to work. That would support the position. The second issue is potentially a hostile work environment. And that depends on what has been memorialized in the communications between the parties. I will say this: employment laws, employment matters are very niche, specific. So I encourage you to book a consultation. They're very fact specific. They're very factual. Okay, as we see, there's this, and this, and this. It's a relationship, an employment relationship. There's a history there. Okay, and that must be evaluated. I do have associates that are the top in employment law matters. Okay, so we can discuss that.
Okay, you said this is live stream, so is there a link where I can copy this to the friend who I'm asking about?
Yes, absolutely. Let me see. I can.
Like, is this you record this and then you paste it there and then people can watch the session later?
Yeah, it's on all the social streams.
Oh, okay.
YouTube, Facebook, LinkedIn, Twitter.
Okay.
Instagram Live we're going to as well. There's a few people signed in on the various platforms. And yes, we post these on the YouTube channel. So it will be public, and we try to provide chapters in there of the subject topics so people can scroll easily. So yeah, we can.
Okay.
Yeah, we can provide her a link to this video, but I do encourage confidential consultations. Every legal matter should be taken serious, and there's a lot of things we cannot discuss here. This is for just general information. This is just the tip of the iceberg. Each case is dependent. Each case falls on its own facts.
Okay. Thanks so much.
There is a question in the chat. How do you handle child custody and family matters? Those are the most gut-wrenching matters for me. So that is not my area. I will say this: as a litigator, family law matters, child custody matters, they are the most litigious. It can be a fight, and the children are in the middle, and it is just not an area that I get involved with. but I do have referrals to lawyers in all practice areas. So please feel free to reach out and we'll get you to the attorney that will be able to help you. So with that being said, we are past the half hour. I like to keep these meetings relatively brief so that we can start our week and have a very productive week. I want to thank Robin, Susan for signing on. As this webinar is weekly, every Monday, except holidays, every Monday, 9 a.m. Pacific Standard Time. Feel free to log in, Coffee with a Lawyer. I want to say thank you, everyone who signed on the social platforms. And I'd like to say take care and take action. Bye-bye.
Thank you.